Good afternoon. This is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida. Call us today for a free in-person consultation regarding any family law case at 561-530-4568 or online at sunshinedivorce.com. Again, this is Grant Gisondo, the family man. Today we're going to be talking about some commonly asked questions and situations in family law litigation cases. We see a lot of clients in our practice. We get asked questions nearly every single day, and we're starting to see the same ones come up over and over. So we're going to address some of those today, give you guys some clarity about what it's like to be a family law attorney. And if you're looking to get a divorce, some things you might be wanting to ask your attorney, hopefully us. So give us a call. So, number one question that we see pretty much every day is, can I get a legal separation? Now, folks, I'm originally from Long Island, New York. Up in the Northeast, the laws are completely different. Up in New York, New Jersey, in those jurisdictions up there, there's such a thing called a legal separation, where through the courts, you can actually be legally separated. You could be technically married, but living complete and separate lives. Here in Florida, nothing could be further from the truth. There is absolutely no such thing as a legal separation in the state of Florida. You either have a pending divorce case, which I'm going to define in a minute for you, or you are married, but no legal separation. So what does a pending divorce case mean? It means that an attorney such as myself went ahead and actually filed a case on your behalf to get you divorced. Once that happens, the clock stops ticking. A 10-year marriage is going to stop, boom, 10 years, 5 months right there, the day that you file it. It's important that you understand that until your case is filed, the clock is ticking. You are incurring marital assets. You are responsible for marital liabilities up until you actually file that case. Totally different than the Northeast. The Northeast does things completely different than we do down here. So the next question that I'm getting quite frequently is, how long is this process going to take? How long till I can stop coming to see you, giving you some money, and seeing you and talking to you every single week? To be completely honest with you folks, I have no idea. I have no idea how long your case is going to take. It could take anywhere from 30 days. It could take 60 days. It could take 90 days. It could take 2 years. It really depends on you and your significant other. Every single case is so different. There are so many issues that can come up in a divorce case. For example, you have the divorce. That's one area. There's something else called equitable distribution, which is all of your assets and liabilities that we have to figure out who's taking what. We have to figure out if you have children, when are you going to see your children, the amount of overnights that you're going to have with your children, your children's expenses, and then plus any maintenance going forward. Is there a claim for alimony? Is there a claim for spousal support? Is there a claim for attorney's fees? This is all stuff that we're going to figure out and determine through the discovery phase of your case. While this is happening, time is passing. But from the day we file your case and we get your spouse served, your spouse is going to have about 20 days to file a responsive pleading to our lawsuit. So right there is 20 days. If everything is settled the next month, I can usually get you for a final hearing and get your case resolved within the next 30 days. So at minimum, 60 days, maximum, well, I've been in cases for 2 or 3 years. It's not completely uncommon for that to happen. Everybody wants to know, well, what if we agree on every single aspect of the case? I always think that's great. The more that you guys can settle and solve without the need for arguments outside the scope of lawyers, the better off that you're doing, the more money you're most likely going to put or keep in your pocket. One of the tools that we use to try to get people to settle is called mediation. Mediation is typically set approximately 60 to 90 days out after all of your financial discovery is completed. What happens at mediation is you have yourself, myself, your spouse, their respective attorney, and a mediator who's a third party basically trying to work through the issues in your case. What this third party is doing is going back and forth between husband and wife or mother and father, back and forth throughout the day as it progresses, trying to get you to come to resolutions about the different issues in your case. Now, mediation can take an hour. Mediation could take 8 hours. I've had mediations where we've mediated for 3 days with breaks, of course. We're not actually going to make you mediate for 3 days straight. That would be cruel. We don't want to do that. So with breaks, we come back and we keep going. I like to completely mediate a case on every single issue to try to come up with as many resolutions as we possibly can before we actually get into the courtroom and start arguing. Why do I like mediation? One, it's much less expensive than trial. I try to keep finances in people's pockets as much as I can. I tell people all day long, I'd much rather your money go to your children than to me, but if you don't want it to go to your children, I'm glad to take it. Also, mediation, it moves a lot quicker. Sometimes if I want to get a case set for a hearing or set for a trial, we have to wait 60, 90, sometime 100 days before the court actually has time to hear your issues. Typically in mediation, I can get you into a mediation within 30 to 60 days. So things are going to happen much quicker. Now, I'm just giving you a little taste about what a mediation is today. I don't want you to worry about it because I know I'm moving quickly. In the future, I promise you, I'm going to do a whole show just on mediation. So you'll have an opportunity to ask us some questions. We'll put all that. We're going to go through the whole process, beginning to end, why it's useful, what's good about it, what's bad about it, and we'll go right there. Again, if you're just tuning in, this is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA. We are a full-service family law firm located in Palm Beach Gardens, Florida. Call us today for a free, totally free, in-person consultation regarding any family law case. You can reach me at 561-530-4568 or online at sunshinedivorce.com. Again, we're talking about frequently asked questions and frequent situations in a family law case. The next question, number 3, that people typically want to know about is, can they get their engagement ring back? Usually guys are asking this question. Can I make my spouse give me that engagement ring that I worked all summer for or all year for? Sorry, guys. The answer is no. You can't get it back. The Florida law is abundantly clear that an engagement ring is a conditional gift. The condition is satisfied on the day that you get married. So as the day you say, I do, you no longer get that ring back. So I do, you don't. There you go. Sorry, guys, the ring is hers. Let's argue about something else because you're not winning this argument. Same things with the wedding band while we're throwing in there. Number 4, is my husband or wife going to take my kids away from me? Most likely not. I can't speak in every situation here. Most of the time, no. Most of the time, both parents are going to spend a substantial amount of time with the children unless very, very rare situations exist, unless there's an issue with, and I mean a real issue with alcohol, drugs, abuse. Some of those crazy situations that are sometimes present in family law cases would severely limit a parent's access to a child. But the courts, the statute, the laws, they're really all designed to encourage and foster a relationship and a frequent continuing relationship between both parents and the child. We're not living in the 1920s anymore where someone's saying, oh, the kids go with the wife every single time. No, that is not true. Nothing could be further from the truth. In fact, the courts want to see fathers, husbands, spending time with their children. And I don't mean spending just weekend time with their children. They want both parents actively involved in things like homework, things like extracurricular activities, and as well as the fun time. So the days where dad's going to take the kid to the zoo and get him ice cream on a Saturday morning and then back to mom to do the homework on a Sunday night, that is no longer happening. Everybody's going to be responsible for their children. Everybody's going to do the heavy lifting, and everybody's going to do the fun part. Again, we're going to be back in just one moment after a quick commercial break and continue talking about frequently asked questions in a family law litigation case.
Non-attorney spokesperson.
Without the proper training, diffusing a highly volatile bomb is not something you want to try by yourself. When a marriage is about to explode, the same wisdom applies. Hire a professional or pay the consequence.
Headed for divorce? Diffuse the matter with the guidance of the law offices of Grant Gisondo. Online at sunshinedivorce.com. That's sunshinedivorce.com. Main office in Palm Beach Gardens.
Okay, folks, we are back. This is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida. Call us today for a free in-person consultation regarding any family law case at 561-530-4568 or online at sunshinedivorce.com. Today we are back. We are talking about frequently asked questions regarding a family or divorce case here in Florida. We have a special guest that popped in. She wants to ask a quick question about a family law matter. So here we go. Young lady, what is your question?
My question is, would a parent be responsible for their child's college education?
That is actually a great question, a question that I get nearly every single day. Again, most people from the Northeast want to know about this. Down here in Florida, to answer your question in the simple way that I possibly can, no, You are not. Believe it or not, you have no legal obligation to pay for your children's college education. Should you? Well, I'm not going to answer that because my personal opinion doesn't matter in this situation. The only thing that matters here today is actually Florida law. Under Florida law, you are not legally obligated to pay for your child's college education, whether it be college, university, or whatever. In fact, your duty to pay child support actually ends when your child graduates high school or reaches 18. Of course, if you decide to sign a settlement agreement and settle your family law case where you're saying that you are going to be responsible for your child's college education, then you will be held under contract law responsible to fulfill that obligation. So no, you are not responsible. Yes, you can make yourself responsible, but the law is not going to make you do it. Now, this question always brings up what I always tell people is that there's a difference between legal obligations and ethical obligations. I'm going to leave it up to you whether or not you have an ethical obligation to pay for your child's college education, but legally, no, you don't. Did that answer your question?
Yes, it did. Thank you.
Okay, great. Okay, on to number 6 in frequently asked questions and concerns in a family law case. Does my spouse need to have an attorney? Well, unlike in criminal law, you do not have a right to have an attorney in a family law case. So a licensed attorney is not going to be appointed to you by the court in any circumstance. Are you required to have an attorney? No. Should you have an attorney? Absolutely. Should you tell your spouse that she should hire a competent family law attorney? Yes. Why yes? Why should they have an attorney? An attorney is going to be fighting me. It's going to make my job harder. Why would you want an attorney? Because not all attorneys are there to fight and make your job harder. Think about it this way. Your spouse is going to trust the attorney that they hired. That attorney that's been hired that they now trust is going to be telling them what the law is. It's going to make your case, one, easier to settle. And if you don't settle the case, it's going to ensure that all the requirements to get into the courtroom and all the requirements to get to trial are properly met. The last thing you want to do is show up on the day of trial and find out that, oops, one of the conditions to get to trial hasn't been satisfied and now your case can't be tried. It's terrible when that occurs. So competent family law attorneys, are they required? No. Should they be involved in a case? Yes. And when I say a competent family law attorney, let me tell you exactly what I mean in this situation. There are many, many different kinds of attorneys. There are attorneys that handle personal injury. There are attorneys that handle criminal law. There are attorneys that handle probate, wills, trust. There are transactional attorneys. There are litigation attorneys. I am a litigation attorney, but I am a family law litigation attorney, what that means is that I only practice family law. I don't have a general practice. I don't take criminal cases. I don't take civil litigation cases. All I take is family law cases. What does this mean? That means that I have spent my entire career studying nothing but the family law statutes, the family law district court of appeals cases, which are binding on other courts, and basically getting known in my community for practicing family law. And what does family law encompass exactly? Everybody wants to know this. Well, I do family law, so what does that mean? You only do divorce? No, I don't only do divorce. I do divorce is a portion of it. I also do timesharing, better known as child custody. I do child support calculation. I do child support litigation. I do past child support. I do contempt. I do modification of final judgments, modification of timesharing agreements. I do adoption. So when I say family law attorney, it's anything in the domestic relations court. It's an all-encompassing term that attorneys typically use to cover a wide range of cases. But I do not do criminal law. I do not do personal injury. I do not do general civil litigation. I have a highly skilled staff, and we focus our efforts on family law. So when I say you should hire a competent attorney for a divorce case, I mean you should hire a competent family law attorney. You want someone like myself that's built their practice strictly around the areas of domestic relations. It makes your life easier. It makes your job easier. And there's a lot of nuances in a family law case that general attorneys maybe don't know, maybe they do. It really depends on how in-depth and how much study they're doing into family law. To tell you a really quick story here, before I started actually practicing family law as an attorney, I was a paralegal at a family law firm. Before I was a paralegal, I was a legal assistant at a family law firm. Before I was a legal assistant, I sat at the front desk and answered the phone. I was making about $8.50 an hour at a family law firm. So my entire legal career has been based on family law. I guess I was kind of set up to do this from day one, but that's where we are today. So again, back to my original answer here. No, you're not required to have an attorney. Should you have one? Absolutely, without a doubt. It's kind of like asking, and this is going to be my final antidote on this point, but it's kind of like asking, I had a heart attack. Should I go to a stomach doctor? No, you shouldn't. You should go to a heart doctor. It's the same exact situation. Okay, so next, everybody wants to know, what are the factors to contribute to child support? And do I have to pay child support? Well, there's a couple factors for child support. And again, I'm going to do a whole show on calculation of child support. I'm going to do a whole show on how to calculate child support, what are the factors in child support, and what are the factors of child custody. But for quick answers today, the factors that contribute to child support right here. Husband and wife or mother and father respective salaries, incomes, first job, second job, third job, whatever amount of money that you're making, it's going to contribute to the amount of child support you pay or receive, and the amount of the overnights that you spend with the child. Overnights, really, really a key word there. I want you to pay close attention to that. It's not days. You could spend 7 days a week with your child, but when we calculate child support, your overnights are going to be 0. So when we're talking about a family law case, we're always interested in the amount of overnights that you spend with the child, not days. The next factor, healthcare costs, healthcare, medical, dental, medications that are prescription-based, of course, go into the calculation of child support, as well as daycare costs. Now, are there other factors? Yes, there are other factors, but these are the big ones that affect the way child support is going to work. Under the child support realm, people are always asking me, I don't want to pay child support. How do I not pay child support? How do you not pay child support? This happens about 1 out of every 100 times where husband and wife or mother and father make the exact same amount of money. Exactly the same amount of money. They have exactly the same amount of overnights on a 365-day calendar. That would be 182.5 overnights apiece. The healthcare costs are split exactly evenly between parties. The daycare costs are split exactly evenly between parties. That will usually give you a child support number of 0. That is extremely, extremely rare. Most of the time, somebody's going to pay somebody child support. Typically, the party that makes more money is going to pay child support to the person that makes the less amount of money. That's typical. But it's also typical that just because you're making a lot of money doesn't mean that you're necessarily going to be spending more of the overnights with the child, so the roles can be reversed. Again, contact an experienced family law attorney that can calculate your child support properly. It is a mathematical calculation. We do have programs on our computers that do this for us because there's no way I could calculate this by hand. Let's just be honest. I couldn't do it. Again, this is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA. To those of you that are just tuning in, I own a full-service family law firm located in Palm Beach Gardens, Florida. Feel free to call me anytime for a free in-person consultation regarding any family law case at 561-530-4568 or online at sunshinedivorce.com. Today we're talking a little bit more about frequently asked questions and common instances in a family law case. The next one that everybody wants to know is, what is a retainer for an attorney and how does that work? A retainer is somewhat complicated, but this really comes down to hiring an attorney. When you found the attorney that you want to hire to have represent you in your case, most of the time they're going to be asking you for a retainer. A retainer is just a prepayment of legal services that's held in an attorney's account set aside for you. Typically it's in a trust account or an IOTA account, and it's yours. So for example, I'm not giving you any fees whatsoever, but I'm just giving you an example here, round numbers. If you paid an attorney a $5,000 retainer up front, and your attorney worked on your case for about a month, after about 30 days, you'd get a billing statement from that attorney. And let's say that attorney billed you $1,000 for that month. They would take the $1,000 out of the trust account. They would go ahead and place it in their operating account. And then your trust account, your retainer would now have $4,000 left into it. This is how most of the attorneys in South Florida, family law attorneys, are going to be paid. They want basically their fees prepaid upfront, sitting in an account for you. Now, here's what varies from attorney to attorney and firm to firm. At my firm, all of our retainers are 100% refundable. So if your case settles, using that same example, and you have $4,000 left in your account and all the work is done on your case, I am going to personally write you a check for $4,000 and give you your money back. I do not keep any money that is not earned. Typically, I have no problem refunding a client's money. I rather them keep sufficient money in their retainer account to make sure that we can get through the case properly and adequately, and then I'll give them back what's left. I don't keep any money that's not earned. Not every attorney does it this way. Some attorneys, their initial retainers are non-refundable. I just choose not to practice that way. It doesn't mean that it's right or wrong. There's no correct way to do this. It's just my preference. I prefer that when a case is over, I kind of like giving my client a check back. It makes them feel good. It makes me feel good. And at the end of the day, I want you to be happy. My goal ultimately as a family law attorney is I want to get you from where you are to where you need to be as cost efficient and as quickly as possible. I want you to be happy. That's what I do. I want to put smiles on people's faces. Okay, so number 9 on my list of frequently asked questions that can occur in a family law case is, I've gotten married in another state. Can I get divorced in Florida? This is actually a pretty fun question because the answer is yes. It's always yes. If you've been living in Florida for at least 6 months, or you and your children have been living in Florida for at least 6 months before filing a divorce or child-related case, Florida has jurisdiction to divorce you. They have jurisdiction over you, and they can actually do it. It doesn't matter where you've gotten married. You could get married in India. You could get married in Indonesia. You could get married in Hawaii. You could get married in Vegas. It does not matter. And believe it or not, yes, a lot of people still get married in Vegas. I don't know. I feel like I should send a thank you card sometimes to the state of Nevada because I get so many cases where they're like, hey, we got married in Vegas and now I want to be divorced. Can you do it? Yes, we can do it. Yes, we do it. And yes, we like doing it. The Vegas stories are always the best, but we're not going to talk about those today. Anyway, so yes, we can do it. Florida has full faith and credit, which means if you're legally married in another state, and the key there is you do have to be legally married in another state, Florida acknowledges that you're married and is happy to get you divorced here. Okay, we're going to be back in just a moment, and when we get back, we're going to continue talking about frequently asked questions in a family law case. We'll be right back.
Non-attorney spokesperson.
Without the proper training, diffusing a highly volatile bomb is not something you want to try by yourself. When a marriage is about to explode, the same wisdom applies. Hire a professional or pay the consequence.
Headed for divorce? Diffuse the matter with the guidance of the law offices of Grant Gisondo. Online at sunshinedivorce.com. That's sunshinedivorce.com. Main office in Palm Beach Gardens.
Okay, folks, welcome back. This is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida. Call us today for a free in-person consultation regarding any family law case, 561-530-4568, or online at sunshinedivorce.com because nobody can spell GisondoLaw.com. Okay, so we have another guest today. That's while we're talking about our frequently asked questions in a family law or divorce case. By the looks of this young lady, she's going to be asking me about alimony. So, ma'am, what is your question?
My question is, am I going to get alimony for the rest of my life?
Do you feel like you're entitled to alimony for the rest of your life?
Yes.
You do. Okay. Well, the answer to your question is one that we get on a regular basis. I have no idea is the answer to your question. To your question, actually, there's a lot to talk about in alimony, everybody. I am going to do a whole show on alimony. The factors are huge. It would take me probably about 20 minutes just to list all the factors for you and all the things the court has to consider. But I'll give you a little bit of a tidbit today because I want to make sure that you're walking away today with at least some information. So, are you going to get alimony for the rest of your life? That I can't tell you yes or no. It's a really, really tough question. So, I always have to make some inquiries. How long have you been married? That's one of the biggest factors in how long you've been married to know what type of alimony is even available to you. And there are many different types of alimony. A quick example, there's permanent alimony, which is alimony for the rest of your life. There's bridge the gap alimony, which is alimony designed to get you over the gap from being married to now being single. And by the way, just because you're a woman, it doesn't mean that you get alimony. Sometimes guys get alimony as well. So I should be asking, am I going to get alimony for the rest of my life? Because I would love alimony for the rest of my life. No, I'm kidding. That's not true. I'm happily married. I don't even want to talk about alimony. Honey, I love you. If you're listening, Just don't mind me today. Anyway, so alimony. How long you've been married? The courts have designed the terminology of the length of a marriage into 3 categories. If you've been married from 0 to 7 years, it's considered short-term marriage. The chance of alimony in that situation, pretty slim. A moderate duration marriage is defined as being married from 7 to 17 years, and a long-term marriage defined as being married over 17 years. Now, we're talking about the day of marriage. That's the day you took your vows, the day you were legally married. I don't care if you dated for 20 years and you were married for 1 year. In that situation, you've only been married for 1 year. It's a short-term marriage. If you dated for 3 hours and then you've been married for 20 years, in that situation, it is a long-term marriage. We only care about the day you actually got married, you took your vows, to the day the petition for dissolution of marriage was actually filed. That's our time frame. So the first thing we do is we classify the length of the marriage. The second thing that we do, there's 2 inquiries in this one. It's a 2-prong test, as we like to call it. Geez, I haven't said prong since law school, but I'm glad I've said it today. I actually learned something. The prong, 1, do you have the need for alimony? Financially, do you actually need alimony to survive? Do you make enough money where you're paying your rent, your health care, you're paying your electricity, your water, taking care of your kids, all that stuff? Do you make enough money to do that? If you do make enough money to do that, then you are not going to get alimony. So in one avenue, we're looking at your need. If you do have a need and you are negative every month and you do require your spouse's contributions to meet the basic needs of life, then yes, a need is present. The second thing is, does your spouse have the ability to pay that alimony? So for example, let's say that you're negative $3,000 every single month. Does your spouse actually have $3,000 available to him to pay you every month and still meet his or her needs? That's a 2-part inquiry. After we get through 1, the length of the marriage, 2, the type of alimony that we're going to get and whether or not need and ability is satisfied, then we could talk about the very, very long statute. I'm not going to talk about the very, very long statute today because we're going to be here for a very long time if I do that. What we are going to do is, I promise you, I'm going to dedicate a whole show just to talking about alimony. So to answer your question specifically, young lady, maybe you might get alimony for the rest of your life if you've been married for a long time, if your husband has the ability to pay the alimony, and if you actually need the alimony. But don't worry, the need for alimony is not determined by what your spouse thinks you need. It's based on what the court thinks you need. There is no specific calculation for determining alimony, unlike child support. Child support is a specific calculation. Alimony is not. Why am I telling you all this? Because this is a huge analysis that needs to be done if you have a claim for alimony, something that should only be done by a competent, experienced family law attorney. I'm happy to talk to you, everybody. I'm happy to talk to you individually about your alimony questions and needs. Give me a call today at 561-530-4568. Moving on to our next question for today. How far can I ask for how long am I entitled to retroactive child support? And hey, what is retroactive child support? Retroactive is not a word that we use every single day. Retroactive basically just means back child support. So when the case is filed, let's say the case is filed in 2017 on January 1st, just to make this simple, you can go back 2 years for retroactive support. That's alimony as well as child support. So 2017, you can go back all the way to January of 2015. And no, I did not have to use the calculator to do that math. So 2 years for retroactive child support, that's how far you can go back. If you've waited, or if your child's 5 years old and you haven't pursued the other person for child support, if you haven't pursued a divorce, you haven't done anything, then I'm sorry, folks, there's nothing you can do. You can only go back 2 years. And that would be 2 years based on income at that time. So yes, we can calculate back child support based on income tax that you've made back in 2016, 2015. We have ways in order to make you happy. We have ways in order to calculate this. It's all part of our special formula that we do in these family law cases. So 2 years retroactive child support in any case. The next question. Here's a question that men always like to ask me, unmarried men, and it's really important you understand that this question has to come from an unmarried man, because if you're married, you automatically have rights to your child if a child is born. If you're not married, you don't automatically have rights. So here's the question. As a father, I went ahead and signed the birth certificate at the hospital. Do I automatically have rights to timesharing and parental responsibility? The answer to this is no. You don't. You have no rights to that child even though you signed the birth certificate. You have no rights to that child even though you are legally the father, even though that you are actually the child's father and there's no dispute whatsoever. Well, how could that be? That's because the legal right can only be established by a court. So if you want to see your child and the mother is not letting you see the child, you need to actually file something with the court in order to establish legal right to timesharing, parental responsibility, child support. None of this is automatic. This is something you're actually going to have to do. Give us a call, the law offices of Grant Gisondo. We can answer all your questions about establishment of paternity, establishment of child support, establishment of parental responsibility so you can actually see your children. We're happy to help you with all that stuff. Give us a call, 561-530-4568. The next question is, when you've been litigating a case for a while, everybody's looking forward to that final hearing. Everyone wants it over with, and believe me, we do too. We want to try to get you done and moving on with your life. So everything is complete. We're ready for that final hearing date. All of a sudden, we send a request to the court's office saying, hey, we're ready for a final hearing. When can we get this done? And they give us a date 90 days away. What now? There's nothing we can do about that. It's completely out of my control. You have to remember a couple things. One, there's only so many judges. These judges have a massive amount of cases assigned to them. Sometimes they just simply don't have the time to get you in as quickly as possible. Sometimes you have to wait 60, 90, 120 days to get that. If there's a trial and you're actually going to try your case, now we're looking at the judge's calendar. We're looking at the other attorney's calendar. You're considering your attorney's calendar. All these things can be extremely hard to coordinate. And this is why sometimes you have to wait a little while for a hearing. It is fair, though. I promise you that everybody will get their day in court. The courts want you to have your day in your court, and your attorneys do. You just have to be a little bit patient and understand the process sometimes takes some time. The next question that everybody likes to know is, I have a minor child, and they want to testify. Can my child testify? Your question is a big maybe. It depends. It depends on the maturity level of your child, depends on the educational level of your child, and it depends on the age of your child. Is a 7-year-old child going to testify in a guess? I'd say probably not. Is your 15-year-old child going to testify? Sometimes. Is your 16 or 17-year-old child going to testify? I'd say the chances might be pretty good, but there's a lot of factors that we have to talk about before we can actually say yes or no. And again, most importantly, you have to understand it doesn't matter what I say. It matters what the judge in your case says. Only a judge can allow your child to testify. It's not something that we can just do because we want you to do it. So again, this is Grant, the law offices of Grant Gisondo, PA. Today we're talking about frequently asked questions here in a divorce or family law case. If you have any questions or if you'd like to hear something that I haven't covered, feel free to give me a call at 561-530-4568 or online at sunshinedivorce.com. Today, again, we're talking about frequently asked questions in a divorce case. One of those questions that comes up a lot today is, do I need a forensic professional? Do I need a forensic accountant? Do I need a forensic psychologist? Sometimes yes, sometimes no. It all depends on you. Neither one of them are incredibly inexpensive, so I try to use them only when absolutely necessary to try to keep some money in your pocket. But in some instances, yes, a forensic psychologist is very helpful. If your children are struggling with spending time with the other parent, spending time with their father or their mother, a forensic psychologist can be very, very helpful in working them through some of their troubles. The same thing with a forensic accountant. If you feel like your spouse is hiding assets, hiding money, siphoning money, wasting money, they have a gambling problem, or they're spending money outside the marriage on another person in the event of infidelity, yes, a forensic accountant can be really helpful not only to the attorneys, but also to the court that can provide them with a beautiful little spreadsheet of what exactly is missing, what exactly is needed. So in some instances, forensic accountants can actually save you some money. But again, that's a conversation, a decision, and an analysis that you need to be doing with your attorney. I do them all day long with clients, and we usually arrive at really happy clients and successful results when we start using professionals and experts in these cases. So I'm happy to talk to you about all those needs. If you're just tuning in, this is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA. We are a full-service family law firm located in Palm Beach Gardens, Florida. You're welcome to call us at any time for a 100% free in-person consultation regarding any family law case at 561-530-4568 or online at sunshinedivorce.com. Why Sunshine Divorce? Because nobody can spell GisondoLaw.com. We'll be right back in just a minute with a few more questions that people frequently ask us in family law cases, and we'll see you in a minute.
Non-attorney spokesperson.
Without the proper training, Diffusing a highly volatile bomb is not something you want to try by yourself. When a marriage is about to explode, the same wisdom applies. Hire a professional or pay the consequence.
Headed for divorce? Diffuse the matter with the guidance of the law offices of Grant Gisondo. Online at sunshinedivorce.com. That's sunshinedivorce.com. Main office in Palm Beach Gardens.
Okay, folks, welcome back. This is Grant Gisondo, the Family Man. Today we're talking to you about frequently asked questions in a family law case. I am an attorney. I do practice family law and family law only here in Palm Beach Gardens, Florida. I offer free in-person consultations for any family law matter. You can call me today at 561-530-4568, but occasionally I am unavailable. Occasionally I am not able to take your call. Most of the time you're going to be talking to my favorite paralegal. Her name is Amy Mitchell. She's with me here today in the office. Say hello, Amy.
Hello.
How are you today?
I'm good, thank you.
Are you excited to be here?
I'm very excited.
I'm excited to have you here. Amy is a Florida Bar certified paralegal. She has the highest accreditation that you could possibly get as a paralegal in the family law field. She's going to tell us a little bit about herself today. She works very closely with me in all of my family law cases. She's going to work closely with all of you in your cases should you choose to work with my firm. I wanted her to say hello. She did say hello. Amy, where'd you go to college?
I went to Indian River State College.
Indian River State County. And you've been involved in family law for how long?
14 years.
14 years as a family law paralegal.
Yes.
Wow. You must have some stories to tell.
Many.
Really? I can only imagine. So, Amy, tell us, what is your favorite type of client to work with?
Organized clients. I love when we give clients documents to take home with them that they need to complete and bring back to us, that they do it in a timely manner, and they bring whatever documents are requested back organized and easy for us to put together and either file with the court or provide to opposing counsel as necessary.
Now, when you say documents that you sent home with him, to me, that sounds like homework. So are you sending people home with homework?
I am.
You are. What are you sending them home with that they would have to fill out for homework? And when you say in a timely manner, now you are a lady, and I'm going to make you be specific today. What do you mean by a timely manner?
Well, initially we send them home with a financial affidavit and a document referred to as the Certificate of Compliance with Mandatory Disclosure. You have 45 days from the date you were served to file both of those documents with the court and provide the other side the same documentation. So when I give it to the client, I do ask them that they get us back the documents within about 2 weeks. Usually they have questions, so I prefer 2 weeks so that I have ample time to review the documents they provided and then set up an appointment to go over all of their questions and finalize the documents so that we can comply with the rules of procedure and make sure they're filed timely.
That is an extremely specific answer. I like it. You've done this before.
No, first time.
Okay, even better. Okay, so you send them home with their mandatory disclosure. You send them home with their financial affidavit. They're allowed to ask you questions on how to do that, help you out with that.
Absolutely.
And you're always available by phone with them, right? To ask for them to answer their questions.
Absolutely.
Great. Okay, so other than mandatory disclosure, are there any other requirements that you're going to make a client complete before we can do their divorce?
In some cases, there is a request to produce filed and interrogatories. So I will, as soon as we get those, if the other side files them, I will call the client. I generally will have the client come in and we'll have a meeting about those documents. They can be fairly cumbersome, and usually they're a little alarming to the clients when they receive them offhand because it requests a lot of stuff. So I like to go over it thoroughly with the client and make sure that they know what they need to provide, and I guess that they understand exactly what it says, because there's a lot of legal jargon in it, I think, that the clients are confused about. We also make sure that the client does their parenting course if they do have minor children. We provide them a long list of providers they can use. And then as soon as they do that, they just need to get us back their certificate of completion, and we file that with the court.
Now, when you say a parenting course, is that like a weekend? Is that like a week long? How do they do that? Where do they do that? Can they do that from their own home?
Most of the time they can do it online, actually. There are still many providers where you can actually do it in person if you so choose. But for the most people, I think doing it online is easier and just more convenient. It's generally about 4 hours. The prices vary. I think they're usually anywhere from about $25 to $50. So it's not incredibly expensive, but it is required. So we try to make sure that the client does it sooner than later so we can get their certificate filed.
Great. And for those of you just tuning in, this is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA, located in Palm Beach Gardens, Florida, where you can call us today for a free in-person consultation at 561-530-4568. We're talking these last few minutes here with Amy Mitchell. She's one of our head paralegals, one of our head licensed by the Florida Bar paralegals at the firm, and there to answer all of your questions, as am myself. Amy, you said that you've been practicing family law for about 4 years, or not practicing, you've been working as a paralegal for about 14 years in the family law field. Why family law? Why not personal injury? Why not criminal law? Do you love your work? Do you love your job? And do you love working for me?
So yes, I do love working for you. I'll start with that first.
That's a great answer. That's a great answer.
I really do. I love family law. I love working with the clients. I know this is a really, really difficult time in their life. And to be a guiding light when they are usually feeling like they're suffering and feel very confused, overwhelmed, don't know which way to go, what way to turn. It makes you feel good to be able to be there for them and show them that there is light at the end of the tunnel. And although you're going through this dark time, that we can guide you through it and get you through it as efficiently as possible. It's, as quick as possible, and do everything in our power to make sure that they get, through this unscathed.
Good. Great answer. I like that you love your job. I love my job too. We want our clients to love what we do for them. We want our clients to be happy. We don't want to destroy their lives. We want to get them from point A to point B as quickly as possible, as efficiently as possible. We want them to take their next step in your lives. We do this because we are competent family law attorneys. We're in Palm Beach Gardens. Give us a call anytime, 561-530-4568. Again, this is Grant Gisondo, the family man. I look forward to hearing from you, and we will see you next week.
Non-attorney spokesperson.
Without the proper training, diffusing a highly volatile bomb is not something you want to try by yourself. When a marriage is about to explode, the same wisdom applies. Hire a professional or pay the consequence.
Headed for divorce? Diffuse the matter with the guidance of the law offices of Grant Gisondo. Online at sunshinedivorce.com. That's sunshinedivorce.com. Main office in Palm Beach Gardens.